If you are over 60 and you own your home, the state already has a comprehensive plan to take control of it the moment you pass away or become incapacitated, unless you file 5 specific documents right now. Every single day, thousands of families permanently lose their childhood homes to probate courts, Medicaid recovery programs, or sudden bitter family disputes simply because their parents waited just one day too long to sign a few pieces of paper. Today, we are going to walk through exactly what you need to file to build an ironclad wall around your home and your life savings. Pay extremely close attention to the screen because the 5th document we will discuss is one that almost no lawyer will ever tell you to write, yet it is the single most important piece of paper your family will ever need to keep them from falling apart. You worked your entire life to pay off your mortgage. You sacrificed, you saved, you worked overtime, and you built a true sanctuary for yourself and your loved ones. But the brutal, unavoidable reality of our legal system is that homeownership means absolutely nothing if it is not properly protected on paper. I have spent countless hours studying the devastating legal loopholes in estate planning that systematically drain family wealth, and I have seen firsthand how hardworking, honest people lose everything to cold bureaucracy. In the next few minutes, we are going to cover the exact 5 documents you must have in place immediately. We will start by completely bypassing the probate court system, move through shielding your physical assets from medical emergencies, and finish with a completely free document that guarantees your family stays fiercely united after you are no longer here to guide them. Let us begin with the first vital document, which is designed to fix the biggest lie you have ever been told about estate planning. You have probably been told your whole life that as long as you have a last will and testament, your home is safe and will smoothly transfer to your children. This is a massive, incredibly dangerous misconception. A will does not keep your home out of court. In fact, a will is nothing more than a formal ticket to enter the probate court system. Probate is the legal process where a judge oversees the distribution of your assets, and it is a nightmare. It is entirely public, meaning anyone can see what you owned and who is getting it. It is painfully slow, often locking your home up for 9 months to 2 whole years. And worst of all, it is devastatingly expensive. Between attorney fees, executor fees, court costs, and appraisals, probate can easily strip away 3 to 8% of your home's total gross value. If your home is worth $400,000, your family could be forced to write a check for $20,000 or more just to inherit the house you already paid for. To completely bypass this trap, you need the first document, a transfer on death deed, or, depending on the state you live in, a revocable living trust. Think of a transfer on death deed exactly like the beneficiary designation on your life insurance policy or your retirement account. When you pass away, the house automatically, immediately, and legally transfers to the exact people you named on that deed. There is no judge, there is no court, there is no waiting period. Your children simply present your death certificate to the local county recorder and the house is theirs. You maintain absolute 100% control of the property while you are alive. You can sell it, you can refinance it, you can take out a second mortgage, or you can change your mind and revoke the deed entirely. The beneficiaries you name have 0 legal rights to your home until the exact moment you pass away. If you live in a state that does not offer transfer on death deeds, you must set up a revocable living trust to accomplish the exact same goal. By transferring the title of your home into a trust, you strip the probate court of its jurisdiction over your property. Do not rely on a simple will to protect your most valuable asset. The transfer mechanism must be legally automatic. Now, what happens if you do not pass away, but you suffer a severe stroke, or an accident, or the early onset of dementia, and you lose the mental capacity to make legal decisions? This brings us to the second document. And the tension here is something most people simply refuse to think about. If you become incapacitated and you are the sole owner of your home, or even a joint owner with your spouse, that house is immediately frozen in time. Your spouse cannot sell it to downsize and pay for your medical care. Your children cannot access your home equity to help you. The bank will not let anyone touch it because the name on the deed can no longer legally sign a contract. At this point, your family is forced to go to court and sue you for the right to manage your life. This is called a conservatorship or adult guardianship. It is a humiliating, agonizingly slow, and incredibly expensive public trial where a judge, a total stranger, decides who gets to control your house, your bank accounts, and your life. You completely eliminate this risk by filing the second document, a durable power of attorney for finances. Notice the word durable. A standard power of attorney automatically becomes completely void the exact moment you lose mental capacity, which is precisely when you actually need it the most. A durable power of attorney remains in full effect even if you develop severe dementia or are lying in a coma. By signing this document right now, while you are healthy and clear-headed, you are legally handing a trusted person, usually your spouse or your most responsible child, the keys to your financial life, but only under the exact conditions you specify. They can step in immediately to pay your property taxes, manage your mortgage, access your bank accounts, and even sell your home if that is what is absolutely necessary to afford your long-term care. You are not giving up your independence. You are actively choosing your own protector before the government forces one upon you. You must ensure this document specifically includes the power to manage real estate transactions, or it will be utterly useless when it comes to your home. We have protected your home from the courts after you pass, and we have protected your finances if you become incapacitated. But we have to address the physical reality of aging and medical emergencies. Imagine your family standing in a brightly lit hospital hallway. You have suffered a massive medical event. The doctors are asking for immediate direction regarding life support, experimental treatments, and invasive surgeries. Your oldest son believes you would want to fight to the bitter end using every machine available. Your daughter believes you would want to let nature take its course in peace. They are both speaking out of deep love for you, but they completely disagree. Because you never put your wishes on paper, the hospital is bound by strict legal protocols and liability concerns, not your personal philosophy on life and dignity. Your family is now deeply fractured, arguing in the worst moment of their lives, carrying the crushing guilt of having to guess what you would have wanted. This is why the third document is absolutely non-negotiable, an advance healthcare directive, which usually consists of a living will and a medical power of attorney. The living will is your voice when you cannot speak. It clearly legally outlines exactly what medical treatments you want, and just as importantly, what treatments you absolutely refuse. Do you want a feeding tube? Do you want to be placed on a ventilator? Do you want cardiopulmonary resuscitation? You make these incredibly heavy decisions now, in the comfort of your living room, so your children never have to make them in a cold hospital waiting room. The medical power of attorney goes hand in hand with this. It legally appoints a specific healthcare proxy to enforce the wishes you wrote down in your living will. And a word of profound advice here. Do not simply appoint your oldest child purely out of tradition. You must appoint the child or the friend who possesses the emotional fortitude to look a doctor in the eye and say, "No, turn off the machine. That is what my mother wanted." It requires an immense amount of strength to be a healthcare proxy. Give this job to the strongest person you know and give them the written legal authority they need to protect your dignity. Now, pause for a moment. We are about to cover how to protect your home from sudden tax hikes, massive medical debts, and aggressive creditors while you are still alive. But do not look away because right after that, we are finally getting to document number 5. As I promised, it is not a legal form you download from a government website, but without it, the first 4 legal documents we just discussed could actually tear your family apart instead of keeping them together. Stay with me. Let us talk about protecting the equity in your home right now, today. The 4th document you need to file is a homestead declaration, or depending on your local jurisdiction, a homestead exemption. As we age, our exposure to sudden, catastrophic debt skyrockets. A single medical emergency, a prolonged hospital stay that Medicare does not fully cover, or a simple car accident can result in a mountain of unexpected debt. Aggressive creditors and collection agencies do not care that you are on a fixed income. They do not care that you are over 60. If they secure a judgment against you, they will look immediately to your biggest asset, the equity in your home. They can place a devastating lien on your property, and in some aggressive cases, they can force the sale of the home you spent 30 years paying off just to satisfy a medical bill. Filing a homestead declaration places a powerful legal shield around a specific, significant portion of your home's equity, explicitly protecting it from the vast majority of unsecured creditors. The exact amount of protection varies wildly depending on where you live. In some areas, it protects $50,000 of equity. In others, it protects $500,000. And in a few specific regions, it protects the entire value of your home, regardless of how much it is worth. Furthermore, in many jurisdictions, filing for a senior homestead exemption also absolutely freezes or drastically reduces your property taxes. We are seeing seniors all across the country being actively priced out of the homes they own outright, simply because local property values have skyrocketed, dragging property taxes up with them. A fixed income cannot keep pace with exploding tax assessments. By filing this simple, often one-page document with your county tax assessor or recorder, you lock in vital tax breaks and build a fortress around your equity. It is one of the most powerful, underutilized financial tools available to any homeowner over the age of 60. Do not leave your home exposed to creditors for another second. We have now systematically shielded your estate. We have bypassed the probate courts with a transfer on death deed or trust. We have appointed financial protectors with a durable power of attorney. We have secured your medical dignity with an advance directive, and we have protected your equity with a homestead declaration. From a purely legal standpoint, your house is in perfect order, but legal documents are completely blind to human emotion. They dictate who gets what, but they never ever explain why. This brings us to the fifth, final, and absolute most important document. It is called a letter of instruction or a legacy letter, combined with a master estate inventory. When you pass away, your children are suddenly forced to navigate a maze of grief, exhaustion, and logistical nightmares. Even with the best legal documents in place, they still have to figure out the granular details of your life. They need to know where the actual physical keys to the house are. They need the passcode to your phone and your computer. They need to know that the water shutoff valve in the basement needs to be turned with a specific wrench or that the roof leaks in the spring. They need the passwords to your online banking, your email, and your social media accounts. Every single day, estates are delayed and digital assets are permanently lost because parents simply forgot to write down their passwords. Your master inventory should list every single account, every subscription that needs to be legally canceled so your estate isn't bled dry by $10 monthly charges, the location of your safe deposit box, and the contact information for your accountant, your lawyer, and your insurance agents. It is the ultimate roadmap to your physical and digital life. But the letter of instruction goes far deeper than just passwords and bank accounts. This is the document where you speak directly to your family, and it is the single greatest tool to prevent sibling rivalry and permanent family estrangement. The probate courts are full of families tearing each other apart, not over millions of dollars, but over a grandfather clock, a specific piece of cheap jewelry, or the way a house was divided. If you decide to leave the house to one child because they sacrificed their career to stay home and take care of you, while leaving the life insurance to the other children, the legal documents will simply state the facts of the division. To the children who didn't get the house, it can easily look like favoritism. It breeds immediate, bitter resentment that can last a lifetime. Your letter of instruction is your final opportunity to explain your logic. It is where you write, in plain, loving English, exactly why you made the decisions you made. You tell them, I left the house to your sister because she needed a place to live while she cared for me, and I left the liquid savings to you so you can put it toward your children's college fund. I love you both equally, and I made these choices to protect you both in different ways. When children read those words, written in your own hand or typed in your own voice, the anger dissolves. The confusion vanishes. They are no longer left to project their own insecurities onto your legal documents. You provide them with total closure. You tell them where you want your ashes scattered. You tell them what music you want played at your service. You remove the crushing burden of guesswork from their shoulders during the darkest week of their lives. A lawyer cannot draft this for you. A judge cannot enforce it. But this deeply personal document is the glue that will ensure your children still sit together at Thanksgiving dinner long after you are gone. If you own your home and you are over 60, the time for procrastination is entirely over. You must bypass the courts with a transfer on death deed or trust to ensure your property transfers automatically. You must lock in a durable power of attorney so a trusted loved one can manage your finances if you lose capacity, keeping the state out of your business. You absolutely must formally declare your medical wishes and appoint a strong proxy through an advance healthcare directive so your family isn't burdened with agonizing medical guesses. You need to file a homestead declaration today to shield your hard-earned home equity from predatory creditors and skyrocketing property tax assessments. And finally, you must sit down at your kitchen table this weekend and write a comprehensive letter of instruction and master inventory to guide your family through the logistics of your life and the emotional reasoning behind your legacy. This is not just about preparing for the end. It is about seizing absolute control of your life right now. It is about protecting the people you love from the harsh realities of the legal system, the medical system, and the devastating potential of family conflict. You built your home with decades of hard work, and by putting these 5 documents in place, you ensure that your home remains a source of wealth, security, and profound peace for your family. I want to hear from you. Have you or your family ever had to deal with the nightmare of probate court, or the struggle of trying to find a loved one's important documents after they passed away? Go down to the comments right now and share your personal experience regarding this topic, so others can learn from what your family had to go through.